To kick that off tonight, I'm going to bring up a friend of mine and our first speaker. His name is Dr. Francis J. Beckwith. So come on up, Dr. Beckwith. We're so glad that you are with us tonight. Dr. Beckwith is a philosopher who teaches and publishes and speaks on a variety of topics and issues in ethics and law and politics and religion, well equipped to work with you guys. He's currently the professor of philosophy and church-state studies at Baylor University. Go Bears, right?
Sick 'em.
That's right. Where he also serves as affiliate professor of political science, the resident scholar in the Institute for Studies of Religion, and associate director of the graduate program in philosophy at Baylor. You're a busy guy, Dr. Beckwith. Yeah. He earned his PhD and his MA in philosophy from Fordham University and a Master of Juridical Studies from Washington University School of Law in St. Louis. Dr. Beckwith and his wife Frankie live in Waco, Texas. So Dr. Beckwith's going to kick us off tonight from Roe to Dobbs. He's going to talk about how the Supreme Court created a right to abortion and where they went wrong. And before he gets started, remember, as he's talking, you can submit questions into that Q&A that's on the platform there in front of you, and there'll be several opportunities to dialogue with our speakers tonight. Thank you.
Thank you, Megan. It's terrific to be here this evening. The title of this Basecamp is If Roe Goes. And so my burden this evening is to explain the reasoning of Roe v. Wade and also to explain what's wrong with Roe v. Wade. A lot of people talk about Roe v. Wade, they talk about abortion rights, but very few people have actually examined, in terms of their own personal study, the reasoning of the Supreme Court in Roe and why so many people have been critical of Roe v. Wade over the decades. So we're going to begin today with a kind of introduction to constitutional law by way of Roe v. Wade, and then I'll have a few things to say about recent cases that the Supreme Court is going to be dealing with and has heard oral arguments about. So Roe v. Wade. I'm going to begin with what is called the holding of Roe v. Wade. And when legal scholars use the word holding, all they're saying is, what's the bottom line? What did the court actually rule in terms of its rationale? What does it say about the issue at hand? And in this case, the court concluded that the law in question in Texas. So we get Roe v. Wade because there was a woman in Texas named Norma McCorvey who was given the pseudonym Jane Roe. She filed a lawsuit challenging the Texas law which forbade or prohibited all abortions except for those to save the life of the mother. The Supreme Court, I have here SCOTUS, which just is short for Supreme Court of the United States. SCOTUS declared as unconstitutional the Texas law. It also declared abortion as a fundamental constitutional right, and it based that on something called the right of privacy. 8 years earlier, there was a case called Griswold versus Connecticut in which the court found a right of privacy, and that case dealt with an anti-contraception law in the state of Connecticut, and that case itself was controversial because there's actually nothing in the Constitution that specifically mentions something like the right of privacy. The court in that case said that you could sort of cobble together certain parts of the Bill of Rights and come to the conclusion that there's something called a right of privacy. And the difficulty the Supreme Court is going to have in Roe v. Wade is, it's one thing to say that a married couple has a fundamental right to use contraception. It's quite another when you have the question of a third party, namely an unborn human being. And we're going to see how the court tries to get around this problem in Roe v. Wade. So the court breaks down pregnancy in Roe v. Wade to trimesters. And it does so in order to tell the states in the United States how far they can legislate on abortion. The court concludes that when it comes to the first trimester, the first third of pregnancy, the government cannot interfere with the right to terminate pregnancy. In the second trimester, the court says that there can be some regulations, but only to protect the health of the pregnant woman. The third trimester, the court says that a state can regulate it significantly, but can't regulate it if it happens to interfere with the life or health of the mother. Now, it's important to remember here, the court is not saying in the third trimester that the unborn human being is now a person under the law. All it's saying is the state can limit abortion if it chooses to. One of the important things to remember about Roe v. Wade is the Supreme Court actually concludes that unborn human beings have no constitutional personhood. And the court picks viability, that is the time at which the fetus can live outside the womb, as the time at which the state has an interest in limiting abortion. Why viability? It's really tough to figure out, because if you think about it, what is viability? It's the time at which an unborn human being can live outside the womb without the benefit of its mother's physical presence. But that means that in some way its development increases as it develops. It increases in moral status. That is to say, as it gets older, it gets more legal rights, or that the more dependent the fetus is, that is, the more dependent the unborn child is, the less protection it's entitled to. The problem with that is that it leads to this sort of strange conclusion that if it's either one of those reasons, that means that the weaker and more dependent one is, the fewer rights one has. And that seems to be contrary to the intuition that most of us have. It sort of reverses what I call the ethical imperative that the strong should protect the weak. It's a really odd conclusion for the court to come to, that, oh yes, when the unborn child is the most dependent and the weakest and the most vulnerable, that is the time at which its life is the least valuable. Whereas in ordinary life, when we think of something like disability studies, and we think about people that are disabled, we think that when people are disabled, when they lack abilities, that the rest of the community has a greater obligation to care for those individuals. And it seems as though the court is reversing it in Roe v. Wade. Now, I want to say a little bit about how the court actually gets the right to abortion. And here, we're going to get into a kind of a little technical reasoning that the court employs, and it's reasoning that has been challenged by scholars from both actually the pro-life and the pro-choice perspective. There are scholars who have been critical of Roe v. Wade as a legal opinion, even though they support the right to abortion. They just don't think it's found in the Constitution. The most important critic in that regard is the former dean of Yale Law School, John Hart Ely. He published an article in the early 1970s, right after Roe, called The Wages of Crying Wolf. And it's an article that I strongly encourage you to read. It's remarkable in its incisiveness and its scope. So how does the court get a right to abortion? Well, Justice Harry Blackmun, who wrote the majority opinion, says in the case, he says that abortion was historically tolerated at common law. That is, that prior to the 19th century, when the states in the United States began passing laws that prohibited abortion, prior to that, when we relied on the common law. What's the common law? That's the law that we inherited from the United Kingdom. It's law that is decided exclusively by courts and not by statutes. And so Blackmun says that before the 19th century, abortion was historically tolerated. In a few minutes, I'm going to explain why that reasoning is flawed, but this was part of his reasoning. The other part of his reasoning was to try to account for those 19th century laws. He said that the purpose of the 19th century laws was not to protect unborn children, but to protect pregnant women from dangerous operations. Because in the 19th century, we just didn't have the surgical methods and technologies that we have today. So therefore, the court reasoned, there is no longer a purpose for those 19th century statutes. And so if there's no purpose for those statutes, then why should Texas's law remain on the books? The second part of Blackmun's reasoning goes to this right of privacy that I mentioned earlier. The right of privacy in Griswold versus Connecticut concerned human reproduction. And so the burden that Blackmun has is this: does the right of privacy extend to something like the right to terminate pregnancy? And he argues, yes, it does. But he has to deal with some counter-arguments because, as I mentioned earlier, what do you do about the unborn human being? It's one thing to say that a couple in their privacy can employ contraception to make sure that they don't become pregnant. But of course, when somebody becomes pregnant, there's a third party. There's an unborn human being that is present. So some of the counter-arguments the court rejected were these. The unborn child is a person under our Constitution. This was an argument made by the state of Texas, and the court says the Constitution does not include unborn children in its text. They're never mentioned. The unborn child is a person in other areas of law. That was another counter-argument. What does that mean? Well, there are inheritance laws and laws against wrongful death that unborn children can be protected by. And yet, Blackmun says that the only reason why I have those laws is because of the interest of parents and the fact that those children in the future are going to be born, but it's not because they are in any way persons under our law. The unborn child is human during all stages of development, which is the most fundamental argument that the state of Texas made in its arguments before the court. And there, Justice Blackmun says, well, experts disagree about when life begins. And so he says, at this point in the court's own understanding, we're not going to issue a judgment. And by the way, that's about the only time you'll ever hear a judge say, who are we to judge? I mean, it's sort of odd. That's why people go to court, right? To actually have judges make decisions. But in this case, Blackmun said, we're just simply not going to issue a judgment about whether the arguments that Texas makes for the unborn's humanity are good or bad. And again, he appeals to disagreement among experts. So the court concludes, abortion is a constitutional liberty subject to increasing restrictions as pregnancy progresses. But under this exception, any restrictions must give way to the health and life of the mother. And so for that reason, most scholars will say that in principle, Roe v. Wade allows for abortion through the entirety of pregnancy because health and life is defined in a very broad sense to include mental health and future life prospects, not something like the pregnancy having to be terminated in order to prevent the woman from imminent demise. So, the practical effect of this is there is no constitutional limitation on the right to abortion up until birth. Now, I want to spend the next couple of minutes just explaining why two of Justice Blackmun's most central arguments are deeply flawed. So the one argument that I briefly mentioned was this one, that 19th century anti-abortion laws were intended to protect women from dangerous operations and not to protect unborn children because they are human beings that ought to be protected by the law. So you can understand the reasoning here, that if, of course, those laws weren't intended to protect unborn children, but just to protect women from dangerous operations, and abortion is not as dangerous as it was in the 19th century, well, then there's no need for the law. Here's the problem with Justice Blackmun's thinking. First off, he relied exclusively, in his opinion, on two law review articles authored by Cyril Means, who was an attorney for the National Association for the Repeal of Abortion Laws. In addition to that, scholarship since Roe has shown that the reasoning is simply false. The best article on this that you can read is one by a law professor named James Witherspoon. It was published in 1985 in St. Mary's Law Journal called Re-Examining Roe. It's not the only article, but it's, I think, by far the best. And what Professor Witherspoon shows is that Cyril Means did not read these statutes carefully, and he didn't look at the history of those 19th century anti-abortion statutes. What Witherspoon tells us is that these statutes referred to the fetus as a child. They were under the parts of the law having to do with laws on homicide. If the woman weren't pregnant, there would be no prosecution. In other words, if a woman were to seek an abortion and she wasn't pregnant, well, there was no unborn child that was to be protected, and so there was no prosecution. The unborn child is mentioned throughout these statutes as a person. And so that key aspect of Roe v. Wade is deeply flawed. And my hope is that when the Supreme Court reevaluates Roe v. Wade, I am confident that the court is going to overturn Roe, that at least one of the justices in a concurring opinion, if not the majority opinion, does show and put on the record the problems with Roe v. Wade in terms of its historical reasoning. The second argument that I want to briefly deal with is the 14th Amendment argument. And this is the argument that Blackmun offers, that the 14th Amendment, which was the amendment passed in 1868 after the Civil War, that includes the portion that says that no one's life, liberty, or property shall be taken from them without due process of law. And Blackmun says that that word person cannot or does not refer to unborn human beings. The state of Texas made the argument that it does, and they offered the well-known facts of fetal development to make their case. So Blackmun ultimately rejects it, I think, very flimsy grounds. One, he says the word person in the Constitution refers, it's mentioned in several places, like the age of one can run for office when they're to be president or the House of Representatives and so forth. And the problem with that is that the Constitution is not addressing the sort of metaphysical question of what is a person. It's just talking about things like qualifications for office. But the most important ground that I think Blackmun is aiming at is this. And here I'm going to quote from Roe v. Wade. Blackmun says, "We need not resolve the difficult question of when life begins, when those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus. The judiciary, at this point in the development of man's knowledge, is not in a position to speculate." He says elsewhere in the opinion that if the state of Texas can show that the unborn child is a person under the 14th Amendment, there is no right to abortion. But by saying this, Blackmun is essentially saying the most important premise to ground the right to abortion is not known, which means that not only does the court not know when life begins, it doesn't know when the right to abortion begins. In other words, there's a symmetrical relationship between the right to abortion and whether the unborn human being is in fact a person. But by conceding that that they don't know that the unborn child is a person, Blackmun is essentially saying there is no constitutional ground to the right to abortion. And he simply doesn't answer the question, and at the end of the day, I think ultimately undermines his own view. Now, most fundamentally, the reason why Roe v. Wade is a failed opinion is not only because it's bad legal reasoning, it also doesn't protect the most vulnerable, or it denies states the right to protect the most vulnerable members of the human community. So we can look at it from that point, that is to say, the sort of basic problem of not allowing governments to protect the most vulnerable, or we can look at it in terms of just the fact that the legal reasoning is flawed. Now, coming up in the next couple of months are several cases that the Supreme Court is going to have to deal with. One, they've already heard oral arguments about. That is the case of Dobbs versus Jackson. That's a case involving a Mississippi statute that prohibits abortion before or after 15 weeks of pregnancy. That's a direct criticism of not only Roe v. Wade, but also a subsequent opinion called Casey versus Planned Parenthood, which is a 1992 case that upheld Roe. And the reason why that's a direct attack on Roe and Casey is that the court in each of those cases says that prior to viability, there's a fundamental right to abortion that the state can simply not prohibit. What Mississippi is saying here, we are going to prohibit it at least between 15 weeks and afterwards, which of course is before fetal viability. So the Supreme Court is going to be faced with this question: is Roe v. Wade and its subsequent opinion that it upheld in Casey, is it going to stand? And then there's the Texas bill, which the Supreme Court declined to file an injunction about. That is, or denied the injunction by an abortion clinic in Texas. That law prohibits abortion after a heartbeat can be detected and in the unborn human being, but there's no government agent that prosecutes or enforces it. It allows private parties to file lawsuits. And so that brings in additional issues that the court is going to have to wrestle with. So let me just say something about the case of, got to go back here, to the case of Casey versus Planned Parenthood. This case, the Supreme Court upheld Roe v. Wade, but it got rid of that trimester breakdown. So this is why when the court deals with the case of Dobbs versus Jackson, it's going to have to ignore this question of trimester breakdown and just deal strictly with the issue of viability. So I'd like to invite Megan to come up.
Yeah.
And
we'll keep talking.
Yeah.
We'll keep going.
And we can, I guess, have a discussion about Roe and.
Yeah. Well, you were just talking about Casey.
Yeah.
So maybe just pick up on that and a couple more things about that, because it did. You said it changed the precedent. How did it do that? Help us understand.
So what happened is that the Supreme Court, at this time, this was 1992, and the Supreme Court looked like it was on the precipice of overturning Roe v. Wade.
Yeah.
Well, what the court did was it kind of gutted Roe v. Wade in terms of it got rid of what, actually a couple years earlier in another case called Webster versus Reproductive Health Services, it got rid of the trimester breakdown. Mm-hmm. So everyone was anticipating Roe v. Wade's going to be overturned. Well, what happened is the court says that it's going to retain the central holding of Roe, which means that there's still a fundamental right to abortion. The states can have a few more restrictions, like things like 24-hour waiting periods and maybe parental consent, but it can't restrict abortion prior to viability if the restriction entails an undue burden. And so the standard changes. And so, I spent a lot of time talking about Roe, but the reality is the law that really is enforced today is Casey. But in the sort of popular imagination, it's really Roe v. Wade. And at the end of the day, the court is going to have to deal with Roe directly.
Yeah, and both of them, it sounds like, because that's what, so we'll see. Well, you're going to see what happens, and this is fascinating. Thank you so much. And you are just a wealth of knowledge. You guys, my work would not be possible without this man's work. So I'm so grateful for his contribution. Just a few questions from our audience that have come in, and they have the ability, by the way, and so those of you who haven't caught on yet, you can enter questions in the Q&A, and you can actually upvote questions that you see that you think, I really do want to hear that answered. And so the upvoted question we have right now is Christine got a newsletter recently that said that abortion laws may legalize killing babies 28 days after birth, so infanticide. How should we respond to that? She asks. Is praying for abortion and signing petitions for pro-life really making a difference if this is where we're headed?
Yeah.
What are your thoughts on that?
So technically, under the holding in Casey, there's nothing that prevents a state from allowing abortion for all 9 months of pregnancy. The only thing that the state can do or individual states can do now is restrict it, but they don't have to do it. So there's no protection for unborn children, even after viability under our Constitution. So in terms of action, surely praying and writing letters and doing that sort of stuff is important. But I think it's also important that for leaders in churches and Christian civic organizations to provide instruction on thinking about the issue of the sanctity of human life. It's something that goes all the way back to the early Christian church. The earliest document that we have, other than the New Testament, is called the Didache, which is the teaching of the 12, and it has instructions for early Christians. And one of them, it says explicitly, no abortion. And no infanticide, which was more widely practiced in the Roman Empire than abortion for obvious reasons, because of just the difficulty of the type of surgery that would be required.
Wow. Yeah, if I'm thinking, it was Christian couples in Rome who would find these babies and bring them home very often, and history says so.
In fact, this is, you mentioned in your earlier comments about issues of race. And what's fascinating, we just went over in one of my classes at Baylor, Martin Luther King Jr.'s letter from a Birmingham jail. And one of the things he mentions is the courage of the early Christians to fight against infanticide as an analogy to the importance of Christians sometimes standing athwart the so-called movement of history.
Yes, not only in Rome, but those Hebrew midwives. Oh my goodness. Absolutely. Well, another audience question that was submitted just prior to the event from Carolyn in Florida, she wanted to know, just kind of an explanation. She keeps hearing people talk about, Roe needs to be codified. And she doesn't know what that means. She said, what does it mean when people say that?
Okay, so several states have already done this. So when I was living in Nevada back in the early 1990s, in 1990, Nevada passed a referendum, which was a popular vote that was put into the state constitution that actually affirmed a right to abortion. And so what basically Nevada was doing, they thought that Roe v. Wade was going to be overturned, and so they wanted to put into the statutory law, in this case the Constitution, which is higher than the statutory law, basically an affirmation and a protection of abortion rights. Well, why would they do that? Well, if Roe v. Wade is overturned, all the state laws that were unconstitutional that had not been removed officially become law. So let's say Texas, although we just have this new law, the law that was overturned in Roe v. Wade was never removed. So if Roe v. Wade were overturned, it would just go back to that original law. So in some of the states that have much more liberal constituencies, they want to codify it, and that's what they mean.
Okay, yeah, we'll hear about some more of that in just a few minutes, I know, with our next speaker. So Janice from Pennsylvania wanted to know, could overturning Roe lead to some kind of loss of medical freedoms? Because the main pro-choice argument is the my body, my rights argument. So she's kind of thinking through, how is this connected? If we overturn Roe, does that mean that in some way we've infringed upon autonomy?
No, all that overturning Roe would do was simply say, the court would be saying there is no constitutional right to abortion, but it wouldn't mean that it would sort of say that it's no longer a federal issue. There is no federal constitutional right to abortion. It doesn't affirm the pro-life position by any means. And my own view is that I do think the Supreme Court, if it's going to overturn Roe, should say something like this. It should say Roe v. Wade is being overturned because we believe that the states have an obligation to protect all their citizens. This is a kind of argument that my friend Hadley Arkus just offered in the magazine First Things in an article about overturning Roe. The court could just make it into, well, every state's going to have a different view on this. It's not a federal issue. They can overturn it that way, or they can overturn it by saying it's no longer a federal issue, but the reason why it's unconstitutional is the state has an obligation to protect unborn human life. So you can overturn Roe in two different ways. So getting back to the issue of medical rights, the justification for prohibiting abortion would be based on the fact that no one of us has the right to intentionally inflict homicide on another person
Yeah.
without justification. Now, there could be cases where pregnancy termination is justified, and those cases are typically life of the mother. Just like we believe there are cases of self-defense, right? They're tragic and unfortunate, but that doesn't take away from the sanctity of the life of the unborn child. It just means that we will have these tragic cases, and we have to act in the way that best advances the highest good.
Yeah, in a broken world like ours, we're confronted with situations like that more often than we'd like. But in cases of pregnancy, thanks to the technology, there's so much we can do now, which is that's good news. So yeah, a little bit ago you were talking about abortion as a fundamental right, and I think that's something that's significant. I know you've written at length on that, but why is that something that's so significant to understand? When people phrase it this way, what kind of right are they talking about?
So in our constitutional law, fundamental right is a right that is so important that if the state is going to restrict it, it needs a really, really good reason. So think of like freedom of speech. Though we think of those rights that are explicitly mentioned in the Bill of Rights. Those are considered fundamental rights: freedom of speech, freedom of religion. So the government can't restrict our speech generally, but there are some cases like I can't commit perjury. I can't defame you. Those laws they do obstruct speech. So to treat the right to abortion as a fundamental right is to say that the state needs a really, really good reason. And of course, the reason that Texas gave in Roe was it's to protect the unborn human being, and Justice Blackmun just punted on that question.
Yeah.
And so one way that the Supreme Court could overturn Roe is to say, no, the state has met its burden of giving a really good reason.
Yeah. Okay.
So a fundamental right is, there's a technical term that that law professors use or that courts use, and that is a law that restricts a fundamental freedom has to pass strict scrutiny, and that just means that you need a really, really, really good reason.
Yeah, interesting. So it's a good thing that fundamental rights are tricky to touch.
Yes.
But the question is abortion like that? And so some are claiming that it is. So that helps with that. Thank you so much for that. This question is a little bit about the connection from Hayuna. She's asking the connection between Roe and Casey. So if Roe gets overturned, will that affect Casey?
That's an interesting question. I think it would, depending on how court reasons. I mean, I think because it all comes down to whether states can legislate prior to viability. And the only way that I think that the court can affirm the Mississippi statute and affirm Casey is to just do what Casey tried to do to Roe, kind of tinker with it. But the problem is that you're going to have another problematic opinion. So the whole point of what the Supreme Court was trying to do in Casey was, let's just try to rewrite Roe in a way to try to solve the abortion debate, and it didn't accomplish that. So to think that the court is going to be able to do that again, I doubt it. Automatically, I mean, because in a way, Casey is the authors of Casey. The three justices that wrote the plurality opinion said that we are protecting the core holding of Roe. I think just by definition, if Roe v. Wade is overturned, then Casey goes as well.